The court. All right. Good morning to all of you. Who will argue today? Mr. Downing speaks up. Mr. Downing will argue today, Your Honor. The court. All right. Spell that for me, please. And then he spells it out. The court. All right. Thank you. The matter is before the court today on your motion, Mr. Downing, so you may begin. I have some knowledge. Let me ask a few facts so that I can be clear. Let me ask the government, or not the government, the special counsel, a few questions, Mr. Dreeben. Mr. Dreeben says, yes, Your Honor. And I will be right back. Dog number 2 needs to go outside now. You. Save me the throw. The next sound you hear will be one of them wanting back in. Okay. Mr. Dreeben, yes, Your Honor. The court. All right. The indictment against Mr. Manafort was filed in February, but it actually was antedated by a filing in the District of Columbia. These allegations of bank fraud, of false income tax returns, or failure to register a report, rather failure to file reports of foreign bank accounts and bank fraud. These go back to 2005 and 2007 and so forth. Clearly, this investigation of Mr. Manafort's bank loans and so forth antedated the appointment of any special prosecutor and therefore must have been underway in the Department of Justice for some considerable period before the letter of appointment, which is dated the 17th of May in 2017. Am I correct? Mr. Dreeben says, that is correct, Your Honor. The court. All right. So when the special prosecutor was appointed, and I have the letter of appointment in front of me, what did they do? Turn over their file on their investigation of Mr. Manafort to you all? Mr. Dreeben responds, essentially, Your Honor, the special counsel was appointed to conduct an investigation. The court says, I'm sorry, answer my question. Did you remember what my question was? Mr. Dreeben, yes, Your Honor, and I was attempting to answer your question. We did acquire the various investigatory threads that related to Mr. Manafort upon the appointment of the special counsel. The court, apparently, if I look at the indictment, none of that information has anything to do with links or coordination between the Russian government and individuals associated with the campaign of Donald Trump. That seems to me to be obvious because they all along predate any contact or any affiliation with this defendant with the campaign. So I don't see what relation this indictment has with anything the special prosecutor is authorized to investigate. It looks to me instead that what is happening is that this investigation was underway. It had something. The special prosecutor took it, got indictments, and then in a time-honored practice, which I'm fully familiar with, it exists largely in the drug area. If you get somebody in a conspiracy and get something against them, you can then tighten the screws and they will begin to provide information in what you're really interested in. That seems to me to be what is happening here. I'm not saying it's illegitimate, but I think we ought to be very clear about these facts and what is happening. Now, I think you've already conceded appropriately that this investigation that has led to this indictment long antedated the appointment of a special prosecutor, that it doesn't have anything to do with Russia or the campaign, and that he's indicted and it's useful, as in many cases by prosecutors, to exert leverage on a defendant so that the defendant will turn and provide information on what is really the focus of the special prosecutor. Where am I wrong in that regard? Okay, and that was all said by the court, the judge. Mr. Dreeben answers back, the issue, I think, before you is whether Mr. Manafort can dismiss the indictment based on this claim. The court responds, yes. Now, I asked you, where am I wrong about that? Mr. Dreeben responds, Your Honor, our investigatory scope does not cover the activities that led to the indictment in this case. The court responds, It covers bank fraud in 2005 and 2007. Mr. Dreeben responds, yes, because, and then the court interrupts and says, tell me how. Mr. Dreeben responds, Your Honor, the authorization for the special counsel to investigate matters is described generally in the appointment order on May. Gets cut off. The court comes in and says, I have it right in front of me, and it won't surprise you to learn that I'm fully familiar with it. My question to you was, how does bank fraud and these other things that go back to 2005, 2007, how does that have anything to do with links and or coordination between the Russian government and individuals associated with the campaign of Trump? Mr. Dreeben responds, so the authorization order permits investigation of two different things that are described in separate clauses. The first are links and coordination between individuals associated with the Trump campaign and the Russian government effort to influence the election. Mr. Manafort was a campaign official. The court responds, you're running away from my question again. You know I'm focused on the indictment that is here. Mr. Dreeben responds, correct. The court responds, it involves facts and circumstances that go back as far as 2005 and come forward. Mr. Manafort's loans from several banks that you all claim he submitted fraudulent statements, I'm asking you, and I've already established this investigation long predated the special prosecutor. And so what is really going on, it seems to me, is that this indictment is used as a means of exerting pressure on the defendant to give you information that really is in your appointment, but itself has nothing whatever to do with it. Mr. Dreeben responds, well, Your Honor, I understand the question. I'm trying to explain why I think that it does have to do with our investigatory scope. And I think there are a couple of premises that may help illuminate what that investigatory scope is. The first one is that in examining an individual who was associated with the Trump campaign and did have Russian-affiliated connections, which Mr. Manafort did, the court responds, are they Russian or Ukrainian? Mr. Dreeben responds, both. Mr. Manafort worked extensively in Ukraine, and he also has business connections and other connections to individuals associated with Russia. In following the leads from those things, investigators want to understand the full scope of his relationship, how he was paid, with whom he associated, what happened to the money, and that leads to the activities that are at issue in this indictment. The court responds, well, it didn't lead to that. This was given to you by the Department of Justice. The investigation was already well underway going back to 2005. Am I correct? Mr. Dreeben responds, well, I think, Your Honor, the investigation has developed considerably with the special counsel. Then the court responds, wasn't it already in existence in the Department of Justice? And they gave it to you when you all were appointed. Mr. Dreeben responds, there were investigations that were in existence, yes, but those investigations were folded together with our overall examination of Mr. Manafort's conduct that fits within B and I, which are, I'm sure, somewhere buried in here as additional comments. So next, the court responds, all right, do you have it in front of you? Mr. Dreeben says, yes. The court responds, all right. I think you would agree that the indictment that we have before the court is not triggered by I, which says any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, bank fraud in 2005, and other things had nothing whatever to do with that. So when you go to number 2, it says any matters that arose or may arise directly from the investigation. Well, this indictment didn't arise from your investigation. It arose from a pre-existing investigation, even assuming that I or double I is a valid delegation because it's open-ended. Go ahead, sir. Mr. Dreeben then responds, so I would take a different look at the way this order works than your Honor's description for a couple of reasons. The court responds, all right. Mr. Dreeben responds. The first is that in provision C, which is in the order, the special counsel is authorized to prosecute matters that arose from the investigation that is described earlier in the preamble and in parentheses B, parentheses I, and parentheses B, parentheses double I. Gotta love the way they write this stuff in the legal terms, don't you? So we are not limited in our prosecution authority to crimes that would fit within the precise description that was issued in this public order. If the investigation is valid, the crimes that arose from that investigation are within the special counsel's authority to prosecute. The court responds, even though it didn't arise from your investigation, it arose from a pre-existing investigation. Mr. Dreeben, while the investigation was inherited by the special counsel. The court responds, that's right, but your argument says even though the investigation was really done by the Justice Department, handed to you, and then you're now using it, as I indicated before, as a means of persuading Mr. Manafort to provide information. It's vernacular, by the way. I've been here a long time. The vernacular is to sing. That's what prosecutors use. But what you've got to be careful of is they may not just sing, they may also compose. I can see a few veteran defense counsel here, and they have spent a good deal of time in this courtroom trying to persuade a jury that there wasn't any singing. There wasn't singing. There was composing going on. But in any event, finish up this point, and then I'll come back to the defendant. Mr. Dreeben responds, well, Your Honor, we are the Justice Department. We are not separate from the Justice Department. The acting Attorney General appointed us to complete investigations and to conduct the investigation that's described in this order. In addition, the acting Attorney General has made clear in testimony before Congress that this order does not reflect the details of the matters that were assigned to us for investigation, and the word arose from that it's contained in B is not a full and complete description. That's meant to be judicially enforceable of the matters that were entrusted. The court responds, so it's written by lawyers but not intended to be judicially enforceable? Mr. Dreeben, it's certainly not intended to be judicially. The court responds, I think you are better off arguing that it's a very broad and that the matters that are here are well within it. But to say that you can write a letter delegating a job to somebody but don't pay any attention to the scope of it is not very persuasive, to say the least. Mr. Dreeben responds, well, and then the court responds, what we don't want in this country is we don't want anyone with unfettered power. We don't want federal judges with unfettered power. We don't want elected officials with unfettered power. We don't want anybody, including the President of the United States, nobody to have unfettered power. So it's unlikely you're going to persuade me that the special prosecutor has unlimited powers to do anything he or she wants. By the way, your office was appointed. you say in May of 2017. Is there any requirement that you make reports periodically to the Attorney General? Mr. Dreeben responds, yes. The court, does that include financial? I think you were given $10 million to begin with. Mr. Dreeben responds, we have proposed a budget and had a budget approved. The court responds, of $10 million? Mr. Dreeben, I believe that's correct. The court says, have you spent that yet? Mr. Dreeben, I am not in a position to talk about what our budget is. The court, are you in a position to tell me when the investigation will be over? Mr. Dreeben responds, I am not, Your Honor. The court, all right. Well, I understand that, and it isn't pertinent to what I have to decide today. And I understand you're not being in a position to tell me, but I'm sure you're sensitive to the fact that the American people feel pretty strongly about no one having unfettered power. Excuse me, I got to get a drink here. We had an interesting judicial conference in the early 90s, I think on the special prosecutor, and they all appeared. I think it was at the Greenbrier. I was the chair of that judicial conference. It was a very interesting time. There were many special prosecutors who appeared, including my former constitutional law professor, Archie Cox, and others. So I had a wonderful opportunity to meet and speak to them and hear their variety of views. All right, I think you answered my question, Mr. Dearborn. If you want to say anything else, now, of course, you're going to have a full opportunity. You're going to have a full opportunity to respond to the defendant's arguments. But I had some preliminary questions which I think you've answered. Mr. Dreeben, I think I should clarify one thing, Your Honor. We are not operating with unfettered power. We're operating within a framework of regulations that contemplate regular reporting to the acting Attorney General, who is supervising the work of our office within the framework of the court jumps in. Is that Rostenstein? Mr. Dreeben says, yes. The court responds, is he not recused? Mr. Dreeben, no, he is the acting Attorney General who appointed the special counsel and who is operating in the framework of internal Department of Justice regulations. This is not the independent counsel that Your Honor was referring to in the conference that you spoke of. This is not a separate court-appointed prosecutor who's operating under statutory independence. We are within the Department of Justice. We're being supervised by an acting Attorney General who has conferred upon us specific jurisdiction and who regularly is in a position to describe to us the metes and bounds of that. There is in this record a memorandum that he has issued on August 2 that explains that crimes that arose from Mr. Manafort's receipt of the payments from Ukraine is within our jurisdiction and was at. And then he gets interrupted by the court. Yes, I have that right here, and I'm glad you raised it because 75% of it is blocked out, redacted. Why don't I have a full copy of it? Mr. Dreeben responds, the only paragraphs that are pertinent to Mr. Manafort are the ones that are contained in this record. The court, well, let me see a phrase that I am fond of that I used to use with my children. I can't use it with my wife, but I'll be the judge of whether it relates to others. I think you should give me under seal to be sure, and you can do it ex parte if you wish, under seal ex parte, a complete copy of the August 2, and I'll be the judge of whether it has anything to do with Mr. Manafort. Mr. Dreeben, Your Honor, if I could ask leave to consult with the relevant components of the intelligence community because that is a classified document. The court responds, yes, of course, you may do that. In any part of it, if any part of it is classified, it won't surprise you to know that a district judge is fully cleared. In fact, I have several espionage trials underway. If CIPA is needed, we will invoke it and use it, but I don't think it will be necessary. I just want to be sure I understand it fully. What you're telling me is that the redacted portions don't have anything to do with Manafort or the issue he's raised. I don't have any reason to doubt, especially because you're making, in effect, a representation, but I'm not bound by that. I need to satisfy myself. That's why I want to know. I think it's perfectly appropriate for you to consult with other parts of the government, particularly intelligence agencies, if they feel some of it is classified. I'm prepared to look at it ex parte under seal. I've got a skiff downstairs where we can put those things, so I'm fully familiar with that. You may take some time. You can have 2 weeks to explore that. Now, thank you. Do you have anything else at this time? Mr. Dreeber responds, I just wanted to connect the dots with my reference to the August 2 scope memorandum. Even if Your Honor is not satisfied that on the face of the May 17th order, the charges in this indictment are within the scope of the special counsel, the August 2 memorandum confirms the acting attorney general's understanding both at the time of our appointment and as of the time of that memo that these crimes were within the scope of our authority. And the explanation for the greater detail in the August 2 memo is that the public order was not the place or occasion to provide details about the matters that the special counsel was to investigate. This is getting rather long.
Wow. Nice work, Thumper.
What do you think so far?
Wow.